Good morning, everyone, and welcome to the last ForoCompetencia breakfast of this year. We have the honor to have Rachel Branderburger with us to give us a view on whether we're facing convergence or divergence in the transatlantic antitrust enforcement. We have had, as you remember, a couple of months ago, a breakfast on a similar discussion within Latin American agencies, and whether we were facing divergence or convergence. And now we have Rachel giving us a transatlantic perspective. And Rachel is an excellent speaker for this topic. She's as you know, a global senior advisor on competition and regulatory policy to APCO worldwide, but she has both lived and worked in the UK, in Europe, and in the US, and she has been seeing antitrust enforcement from the public sector. She was a special advisor on international issues to the DOJ's antitrust division in Washington, and she was also a partner at Freshfields in Brussels and in London. So she has also worked as a consultant at Home Levels. Currently, she's also a research fellow, a visiting research fellow at the Oxford University's Institute of European and Comparative Law. So, without further ado, Rachel, thanks again for the invitation, for accepting the invitation, and the floor is yours.
Well, thank you so much, Julian. My thanks to you for this great opportunity to talk about transatlantic antitrust and to ask about convergence and divergence. I'm very grateful for this opportunity, and I'm also delighted to spot a number of familiar names, and may I even say friends, in the list of participants today. So, convergence or divergence across the Atlantic. I think it's generally believed that the preference by agencies to intervene in matters has shifted from Brussels to Washington, and that the US Department of Justice and Federal Trade Commission are now seen as tougher and more interventionist than the European Commission. That wasn't always the case, and on this slide, which I hope you can see, I've put up the classic GE, Honeywell, Boeing, McDonnell Douglas train wreck, so-called train wreck, to remind us that over 20 years ago, it was the European Commission that was intervening in relation to headline-making mergers between US companies. And that more recently, it's been the European Commission that at least has fully investigated vertical mergers, not actually prohibited them, but investigated them, whereas until recently, the US agencies are sort of seen to wave them through. And I think this perception of greater toughness, for want of a better word, on the in Brussels than Washington, traditionally is also because the European Commission has taken action against big tech companies for longer than has been happening in Washington. But now we seem to be seeing a shift to the other side of the Atlantic with expansionist merger theories of harm and a preference, as I'll go on to explain in more detail, by the US agencies to litigate cases rather than to settle them, even if they risk losing in court. what I've been talking about so far is largely about mergers, but I believe this story is not only about mergers, and it's actually much more complicated than a shift from Brussels to Washington. I think there are a lot more nuances than that. Julian, as I go on, I'm just realizing that without the full screen, maybe we're losing the right-hand part of the slide. So I'm just having a technical discussion. Maybe I should move on to the full screen.
Okay.
Would that be good?
Yes, of course.
No, I'm sorry. I'm having a technical problem there. But we'll proceed without the full screen.
We need to see the full screen.
Okay, fine. That's fine. Apologies. Let's focus back on convergence or divergence. So I can't go very far talking about transatlantic antitrust convergence or divergence without mentioning the most recent and high-profile case involving Microsoft and Activision, where, just to remind you, as I'm sure you know, the investigations, particularly by the FTC, the European Commission, and the UK Competition and Markets Authority, the CMA, have really brought the convergence and divergence theme or issue to mainstream media headlines, and not only an issue just for the antitrust world, but more generally as well. I'm aware that other agencies around the world, including in Latin America, also looked at this transaction. And maybe we want to talk about that when we get to the discussion. I think this case really demonstrates the complexities of transatlantic antitrust for a number of reasons. First of all, we have the UK Competition and Markets Authority as a player in the transatlantic antitrust world these days, since the UK exited the European Union, and the CMA is seen as an aggressive and interventionist agency. This case also illustrates that for the FTC in this case, but also the DOJ in Washington, to stop a merger, they actually have to go into court to do so and get a court to injunct the merger. They can't do so themselves. So in this case, the FTC wanted to stop the merger, but it was unsuccessful in court. So again, a nuance in the convergence divergence story. This case also illustrates that neither the FTC, nor the DOJ, nor the CMA currently are in favor of behavioral type remedies. We can discuss whether the settlement that the EU took was behavioral, structural, or quasi-structural, and labels are always a bit oversimplifying anyway. But we're in a world where the FTC and DOJ don't really like taking settlements in the mergers context. So all of that was at play when we got to a situation where the European Commission approved this high-profile deal with remedies. The FTC tried unsuccessfully in court to block it, and the CMA, as is well known, reviewed under a background of the parties appealing the case for judicial review to the Competition Appeal Tribunal, the UK revisited the case and reversed the original prohibition, taking a settlement. So a complex and very topical example of transatlantic antitrust. And that's not the only case, of course. Just to call out a few others, we have the Cargotec Konecranes case, where the European Commission accepted remedies. The CMA rejected the remedies that the European Commission had accepted and prohibited the merger. And the DOJ, in this case, was prepared to litigate. The parties abandoned the deal. Similarly, in a way, Aon Willis in the insurance sector, EC accepted very extensive remedies. DOJ was prepared to go into court to block the case. Parties abandoned the merger. Slightly different, Penguin Random House, Simon & Schuster. DOJ went into court and won to block the case. It's one of the few cases that the DOJ, FTC in recent years have actually won in court to block the merger. Parties abandoned it. And of course, the ongoing Illumina Grail saga, again, a complex story. European Commission prohibited the case. FTC sued to prohibit. All of the commissioners, both Democratic and Republican, wanted to block the merger. The administrative law judge within the FTC denied the suit. So this was actually not divergence at agency level. The divergence comes in when you look at what happens at the court level. And of course, there's litigation ongoing both sides of the Atlantic. But I also just want to take a moment to remind ourselves on this slide, you can read it for yourselves. This is what I've called the traditional view of convergence and divergence between the EU and the US antitrust regimes. I think this is a very nice way of putting it from a speech by then FTC Commissioner Maureen Olhausen in 2016, where she reminds us about the big picture divergence and convergence transatlantically. It's a good summary. I often use this for my students when I'm speaking. Keep this slide in mind because I'm now going to layer on the developments over the past few years and to show you that this is actually was completely correct when Maureen made this statement, but life is now a lot more complex. So we come to the current DOJ FTC leadership, who are telling us on this slide that they believe that enforcement has been lax in the past. Not everybody would agree with them, but that is the view of Jonathan Kanter and Lina Khan, that they are sending messages of strong enforcement. And they are also claiming that this approach that they are taking is well rooted in existing law and precedent. And they're saying that not only to justify their own approach, but also to seek to persuade the courts to uphold their complaints when they go into court. Because as I've said, the final voice in the US is the courts, not the agencies. So just to remind ourselves, and I'm sure this is very familiar to all of you on this discussion this morning, just to remind ourselves about how US antitrust, its main foundations, and here too we see a difference already transatlantically. And this partly explains why we get convergence in some areas and divergence in others. So we've got the foundational provisions of Section 1 and Section 2 of the Sherman Act. And if, as you read these two sections, you also have in mind the foundational provisions of Articles 101 and 102 in the European Union, you'll say to yourselves that Section 1 of the Sherman Act is pretty similar to Article 101.1 of the European Treaty, but you'll also be saying to yourself that Section 2 of the Sherman Act and Article 102 of the European Treaty differ in some important respects. Particularly in the US, there's an attempt to monopolization can be unlawful, whereas in the EU there must be an abuse. And although this is case law rather than in the statute, you know, of course, that dominance under Article 102 can arise broadly at 40% market share, whereas traditionally, at least, market power under Section 2 has a much higher threshold of about 70%, broad brush. To go on just quickly to remind ourselves on the mergers side, Section 7 of the Clayton Act has a substantially lessening of competition test. Compare that similar but not quite identical with a significant impediment to effective competition test under the EU merger regulation. I would draw your attention to the word may in the Section 7 language. The current DOJ and FTC put a lot of weight on that word to justify their increased intervention. And I should also throw the UK into this discussion from a transatlantic point of view. I should also, of course, put Germany in and other major jurisdictions in Europe who also have their own national regimes. The UK has an SLC test like the US. I have Section 8 of the Clayton Act that prohibits interlocking directorships or officers in competing corporations if the effect is anti-competitive. It's an interesting provision being used quite actively by DOJ and FTC these days. It doesn't have counterparts in Brussels. And last but not least is Section 5 of the Fair Trade Commission Act. So FTC and some states, but not DOJ, have this provision regarding unfair methods of competition and unfair or deceptive acts or practices. And I'm going to come back to those. Those are the building blocks. Also, the building block of the US system being multi-tiered. You know this. You know there are two federal agencies with overlapping jurisdiction, although only DOJ has criminal enforcement powers and only FTC has consumer protection powers. Otherwise, the powers on the civil side are overlapping. Many states have their own antitrust laws, which they may enforce themselves with other states, with the federal agencies. But the biggest difference, again, just to stress this, is that the agencies in the US have to go into court. They themselves don't have the final word. Even settlements, many settlements need to go through the courts for approval. So against those building blocks, but I thought it was helpful, but I hope it's helpful just to bring those back to your front of mind. I've put this slide together for calling it the current debate in US antitrust. It actually started a few years ago. It really started in some respects with the work on concentration that the Obama Council of Economic Advisors did, and it's continued since then. In many respects, the issues that I've listed on this slide, and this isn't really an exhaustive list of current issues, is familiar both sides of the Atlantic and in many other jurisdictions around the world. But a couple of points to just highlight here. I would say that there's a higher focus on labour mobility and low wages in the antitrust enforcement agenda in the US than the EU. And that's always dangerous when one makes generalizations. Someone's going to tell me I'm wrong and they don't agree, but let me just put that out for debate. I would say, conversely, that the EU and some member states, notably the Netherlands and the UK, are focusing on sustainability issues, which is not a feature of federal antitrust enforcement, although it is featuring at some state levels. And I would also just draw attention to the UK focus on cost of living concerns and maybe the German focus on fuel cost issues, although that's not only just a German focus. Also, we can't go any further in this presentation without focusing on big tech and the digital sector generally. The focus here also began a while ago. It actually began in the previous administration, where there were major hearings held in Congress. The CEOs of the big four tech companies and many others gave evidence. Some of this happened during COVID. This was the Amazon, Apple, Facebook, and Google CEOs all gave evidence virtually, for example. The Democratic there's a Democratic endorsed, is the correct way of saying it, staff report from the House, very lengthy report, one of the early reports globally on big tech, which made far-reaching recommendations. Take a look at what's on the slide here. These are issues that have also arisen in the EU and elsewhere across the Atlantic. There was some bipartisan support for bringing legislation. Some of the draft bills that were tabled in both the House and the Senate were bipartisan, but none of them passed, and still we have no federal legislation through Congress in this area. Contrast this with, as you well know, the European Union's Digital Markets Act, the DMA, which is now up and running. 6 companies have been designated as gatekeepers in September under that legislation: Alphabet, Apple, Amazon, ByteDance, Google, Meta, and Microsoft, in relation to 2022 core platform services. The deadline for challenging those findings was last week, and Apple in relation to the App Store, ByteDance in relation to TikTok, Meta in relation to Messenger and Marketplace have all challenged the designations and will be on their way to court in Luxembourg. The next milestone under the DMA is that gatekeepers must agree compliance procedures with the European Commission by March next year. This is all about interoperability and access and opening and closed ecosystems. I think the European Commission has recently put it well. It said DMA implementation is a process rather than a big bang. It will require time and a change of culture. And in the UK, we have a sort of counterpart, but a somewhat different approach, a rather more according to the UK government, individually tailored approach of regulation of big tech, currently going through the UK Parliament, the Digital Markets, Competition and Consumers Bill, which I think is unlikely to come into force before spring of next year at the earliest. But here we have an illustration of a divergence the other way across the Atlantic. Legislation on the books or coming onto the books, German legislation as well, whereas there is nothing coming through the US Congress at the moment. Partly because of that, congressional stalemate in many areas, but we're focusing on big tech for the purpose of this presentation. So no federal legislation on the books or really on the horizon, on the near-term horizon, I would say. But nevertheless, we do have some landmark federal cases being brought in court in the US. So we have the FTC suing Meta, then Facebook, originally in December 2020, which, just to recall, is actually under the previous administration. And then actually, and I don't need to go into the details for the purposes of this presentation, the original complaint was amended and refiled in summer 2021. This important piece of legislation focuses on Meta's so-called buy or bury strategy in relation to potential competitors and startups, including all the way back to the acquisition of WhatsApp and Instagram, although those acquisitions were failed with the US agencies at the time, and the US agencies took no action, and I'm taking no position on that situation. I'm just making a statement of fact here that raises an interesting question. Could there possibly be divestment of acquisitions so many years later? I think I'm right in saying there's no trial date fixed yet. Litigation takes a very long time in the US. So contrast this with the enforcement that the European Commission, the UK CMA, the German Bundeskartellamt, and others have taken or are taking in relation to Meta on the other side of the Atlantic, although the focus of those investigations is different from this piece of litigation. So I'm not in any way saying that these are mirror images in terms of the substance of the cases, but we are seeing different levels of activity. To complete the picture, under the prior administration of federal litigation in the US, I must draw your attention also to the case that the DOJ started against Google in October 2020, just before the presidential elections the following month. This case is currently in trial. The DOJ rested its case at the end of last week, i.e. that means finished presenting its case. And there will be some closing arguments early in the new year. And then I think the general thinking is that judgment can be expected sometime during next year. Couple more points here. As Associate Attorney General Gupta says nicely in this quote, this may be a novel market for the courts to be looking at, but the legal theories here are not novel at all. This is very much the early 2000s Microsoft type thinking, but in the big tech age. And that, of course, is also this is deliberate litigation strategy to enable judges to feel that the law is not being extended here. This is existing law to, if you like, new facts. Judgment in 2024, whatever it is most unlikely to be the end of this case. Whoever loses will, I would imagine, consider appealing, but also this judgment will be about, will only be about liability. So after a liability finding or finding of no liability, but if there's a finding of liability, there would then need to be a whole nother stage of litigation about remedies. So again, this case has a long way to run, as well as the possibility of appeals. And again, you'll see a focus on search like the European Commission had in relation to Google, but somewhat different arguments about what the unlawful acts here in this case are. More recently, under this administration, the DOJ has filed a case earlier this year, joined by some states, in relation to Google's ad tech activities, which they believe are unlawful. There, of course, are European Commission and CMA ongoing investigations into the ad tech space as well. This case may go to trial faster than the previous Google case. It's been filed in a court that has a so-called rocket docket and will actually go in front of a judge. But watch this space. Last but not least of this foursome of major litigation cases is the litigation that FTC has started against Amazon, filed in September, also joined by states, 17 states in this case. This is a very far-reaching, very broad complaint about Amazon's, or many of Amazon's activities, and the range of violations that's alleged is much broader than what was under focus by the European Commission or the CMA in relation to Amazon, both of which investigations have now been settled. So once one comes out of the mergers context and looks, as I've been doing the last few slides in relation to conduct, one sees we're quite a complex convergence, divergence story transatlantically. I also shouldn't talk about transatlantic antitrust without also layering in the really groundbreaking executive order that President Biden issued in 2021 to promote competition in the American economy. Antitrust has really become quite political in the US. Antitrust featured in several of the presidential candidates in the 2020 elections campaign speeches, actually not really in President Biden's. And antitrust sort of became part of the general discussion in a way that it hasn't for over 100 years in terms of political campaigns. This executive order, which again is very unusual, quite historic, has set out, and this is happening in practice at a policy level, really a whole of government approach to issues where competition across many sectors, some of which I put on the slide, competition has a role to play. DOJ and FTC are working alongside the Treasury Department, the Department of Agriculture, DHSS, transportation, and so on, at policy levels, not at investigation enforcement levels, to try to bring improvements to the economy. And this is the background against which many people talk about the increased politicization of antitrust. As to which, just let me run through quickly. So vigorous enforcement of antitrust laws now in the US. This slide reminds you that the US Department of Justice and FTC are updating the merger guidelines. They put aside the previous guidelines. They're combining vertical and merger and horizontal mergers into one set of guidelines. They're using presumptions about unlawfulness in a way that hasn't been used for many years. They are focusing on the digital market and a number of other issues. These are still in draft form. There have been literally thousands of comments submitted in the consultation process. So we have yet to see what is going to emerge as final guidelines from this process, and indeed when they're going to emerge. And they're really drafted, as much as anything else, as messages to the courts as to how the federal agencies would like to see enforcement in the future. So when the final versions are going to emerge and how long a life they will have are very much open questions at the moment. For the purposes of the convergence divergence story, I would also draw attention to the fact that some of the approaches, particularly the focus on presumptions, 30% market share, which is really the Philadelphia National Bank sort of presumption, 50% foreclosure effect for vertical mergers. I mean, we can debate, but I can see some divergence opening up transatlantically between the US approach and the European Union approach if these presumptions find their way into the final text. Although I would say that both European Commission official Olivier Guessin and Sarah Cardell from the CMA have both said that they support is their word, these new draft guidelines. So watch this space. I think we can jump this slide. I think I've already covered these issues when I was opening. Just to remind you here, I talked at the start about Section 5 unfair competition practices, the FTC's extra and important tool for enforcement. A majority of FTC commissioners put aside the previous guidance as to what Section 5 means and have adopted guidance with a much more expansive interpretation of Section 5. And if you take a look at what is actually laid out in that, remember this is a policy statement, not law, you would find great similarities, in my view, between not just exclusionary practices, which we've already understood the US focuses on as well as the EU, but also in EU terms, what the EU would regard as exploitative abuses as well. So again, are we seeing a change here in the convergence divergence story? And I would also just draw your attention to the fact that DOJ has been seeking to extend, I should say, not actually with a great deal of success so far, its criminal jurisdiction into not only classic cartels, but also into Section 2 monopolization cases and into the no-poach and wage fixing area. And of course, the European Commission has no criminal powers, nor do most EU member states. And the CMA hasn't to date been a major user of its criminal powers. President Biden, at the beginning of this year, asked the new Congress, please, to pass big tech legislation. That hasn't happened to date, so a big divergence transatlantically. The Biden administration is seeking to try to institutionalize through these guidelines and merger guidelines and whole of government approach the reforms that it has been promoting, so that they outlast any particular administration. We'll see what happens, and that, of course, will play, whether they do remain with a long life or not, will play into the convergence divergence story. Two final slides. One, to step away from the enforcement level and to remind ourselves that at a higher policy level, transatlantically, there are various forums, fora, where there is opportunities for dialogue across the Atlantic between the agencies on each side of the Atlantic, or indeed governments on both sides of the Atlantic, on convergence or divergence on at a policy level. This, of course, is separate from and alongside dialogue at multilateral organizations like OECD and ICN. And last, let me remind you that 2024 is really the year of many elections around the world, including transatlantically. So we will be having elections in the US. November next year, we have EU parliamentary elections in the middle of next year. We have several EU member states with elections next year. We have the UK with an parliamentary election by early 2025 at the latest. I don't have a crystal ball. I don't know whether any of you listening to this have crystal balls as to what the outcomes of these elections are going to be on both sides of the Atlantic. But the outcomes could well have an impact on transatlantic antitrust and the currently complex convergence, divergence story, as well as, of course, impact on many other aspects of our lives. So let me leave this here. I hope this has helped to set the scene about transatlantic antitrust and to stimulate your short questions, agreements, disagreements, comments. Thank you very much indeed for this opportunity.
Thank you, Rachel. Now we're open to questions. I have a first question to raise to Rachel. You mentioned the. Can we say that instead of being a convergence on the big tech, we can see a convergence on the political demand to face big tech? But even within the United States, can we talk about a convergence on criteria? You mentioned that the key decisions on the FTC were with vote 3-1. I suppose that the one was the Republican vote. Do we have convergence within? Do you see convergence within the United States with regard to antitrust enforcement?
And that's a great question. Thank you, Julian. And I think you sort of know what the answer is as well. I oversimplified when I was talking. So thank you for raising this. At a political level, I think we have some convergence on both sides of the aisle, but not fully at all. But let me answer it this way. Some of the legislation that was making its way through Congress was bipartisan, with some Democrats and some Republicans, and there was agreement that something had to be done about big tech, but why? And that was where they met. But why? They had different views for, and again, I'm overgeneralizing. So the concerns about the anti-competitive effect on innovation, on new entrants and so on, were very much the concerns of some Democrats. For example, Senator Amy Klobuchar, who was leading some of this legislation from the Democratic side. The concerns of Republicans who supported this legislation, and some of whom were co-sponsors of some of the key pieces of legislation, came more from, and again, I'm generalizing, came more from concerns about the impact of big tech on democracy and free speech and issues like that. So they met in the middle. They met for a piece of legislation, but their incentives for getting there were often quite different. But we did have some legislation in both houses before it got to going through the houses, and then would have had to be reconciled between the pieces of legislation. Some legislation got quite far, and also I can make this point as well. Some of the legislation was extremely far-reaching because it covered not only big tech, but also significant changes to antitrust law generally in the US. But I'm not the political expert, but nobody's expecting to see any legislation through this side of the elections next year. I hope that answers your question, Julian.
Yes, definitely. Does anyone has any questions or comments?
I'd love to hear some people, would like to comment on my transatlantic perspective, but I'd also love to hear how this plays from a Latin American perspective. Julian, if we can broaden this a little bit as well, we're talking convergence or divergence there.
Well, I think that it definitely has an impact, especially considering that most Latin American jurisdictions have taken into as reference both the EU and American antitrust regimes for different purposes in different manners. But I think that the fact that there is a discussion nowadays on the fact that what has been done for the past 40 years has been wrong is not a good signal for those who have accepted the recommendation to follow this path. And I think that additionally, to broaden the scope of competition law to issues besides the consumer welfare, I think that it opens a Pandora box that in Latin America can be unpredictable what the outcome can be, because it can lead to changes that are totally unexpected. It could be unexpected, and in fact, we have seen already the debate on that, and we have had, with even without having the U.S. Questioning what the goals of antitrust were, we have had the challenges of that in many Latin American jurisdictions. As you know, this is something new for in historic terms for Latin American countries. I don't know if someone else wants to jump in and add their perspective.
Whilst people are thinking, many arguments going back to congressional legislation or not in relation to big tech. I think people were surprised at how quickly the DMA legislation in the EU got through the processes and became law. And there is the usual concern that US companies don't like being regulated by the European Commission rather than so that's a driver, but I think I don't think it's going to result in, and I'm seeing we've got a question, so I'll just finish my comment very quickly. I don't think that's going to result in rapid progress towards big tech legislation here in the US, but I think it is playing out in the AI context, which I haven't mentioned. But there's a lot of focus, which is competition, antitrust, and many other issues as well. There's a lot of focus on, from a US point of view, we don't want to get left behind again. We must get ahead on what are we going to do about AI. We need to have an answer coming out of the US, whilst the EU is also working on its answer. So I think we will see whatever the answer is going to be in relation to AI coming out faster than we have seen in the big tech area.
Oh, there's a recent book, very interesting book called Digital Empires, which dedicates a lot of the book to analyze the different models that are in conflict, and it is going to be the American way, the Chinese way, the European way, and so this is definitely, as you said, something bigger than antitrust.
Yes, we have a great question here, Julian.
Yes, Eric, do you want to post it yourself, or you want us to read it? Okay. Go ahead, Rachel, if you want to.
So the question relates to the role of the states in the US. And absolutely, as the question says, most states have their own antitrust laws, which are similar but differ, and I am not the expert on this, but differ in different ways from the federal law, both in terms of the substantive law sometimes, and also in the remedies that can be sought. Each state enforces its own laws. And of course, they have enforcement powers way beyond antitrust in all sorts of other legal areas as well. Many states have very little, they'll all tell you they have very little resource to devote to antitrust. So there are, again, a generalization. There are a few states that are major players in the antitrust area: California, New York, Florida, Colorado. I'm sure I'm unintentionally, rudely forgetting some other key players as well. And they will focus largely on matters in their own states. Not all of them have mergers and loss by any means. A lot of them will focus on conduct issues, on labour issues, on hospitals, on local pricing issues, things they can do on their own or maybe as a group of states. Attorneys General at state level are all political appointees. So there's a political identification/divide issue here between states as to which ones collaborate and which ones don't with each others. They don't need to agree on the answer, the question about unified decision, if they're enforcing in relation to their own states, obviously. Where they need to find common ground is if they're trying to come together as a group of states, or if on their own, or if they're coming together alongside either DOJ or FTC legislation. And that's that. I mean, I was coming at this from a federal level today, because I think that's more the transatlantic piece, although I should make a qualification there, which I'll do in a second. You know, there will be sufficient commonality of interests on the cases where they collaborate. But I don't know the statistics, but I would think it's only a proportion of the cases that they bring that they are actually collaborating with other states or with the federal agencies. So it's a very different institutional setup from those of us that are familiar with the European Commission member state, ECN, the European Competition Network kind of setup. There isn't a framework. It's very different, but it seems to work. You know, for example, the expanded view of an interpretation of Section 5 of the FTC Act that the FTC has put out. Some states have their own Section 5 type pieces of legislation. They're called little FTCs, little FTC acts. And it remains to be seen whether some of those states, some of the democratically led states, you can't get away from politics very easily in US antitrust, also adopt the expanded approach that the FTC has. From a transatlantic point of view, I should make the point that there are some states, Texas is another one that I should have mentioned, that particularly in the big tech area, are doing their own outreach, dialogue, cooperation with the other side of the Atlantic, with the European Commission, with some member states in relation to these very important cases. You know, not jointly enforcing, obviously, but having cooperation type, dialogue type discussions. I know New York, for example, and Texas previously have had their own transatlantic dialogue on cases entirely separate from what DOJ or FTC might be doing transatlantically. So I hope that's a sort of answer to your case. It's not straightforward. It's a short answer to your case, to your question.
Thanks. There's a word that you mentioned in your response that caught my attention. Usually that was not heard. A word was not heard when talking about U.S. antitrust, which is you said there's a lot of politics. Usually there's a lot of policy, not about a lot of politics in U.S. antitrust. So that perhaps is a a change of an era, or it is something that it was more present than we thought always.
Is that a comment or a question, or both?
Both.
Both. Okay. It's a great comment and question. Last week I spoke in Washington, DC. I was fireside chatting with Edith Ramirez, the former FTC chair, and a former colleague of mine when she's at Hogan Lovells when I was at Hogan Lovells, at a GCR Women in Antitrust conference. And the topic of the fireside chat was politicization of antitrust, which was a nice topic for me to be asked to talk about in my role now as a policy advisor at APCO, rather than a day-to-day practicing lawyer, although I'm still a lawyer and I think I still think like a lawyer as well. And in trying to answer that question, there's a sort of traditional view of the enforcement swings from one direction to another with change of administration, Republican, Democratic in the US. The studies actually show over the years that there's not been a huge swing. There's some changes maybe at the margins, cases that wouldn't have been brought up or the other way back. What we are seeing now in the current administration, and we don't know what the future is going to bring from that point of view, although I think the efforts to institutionalize, to use DC's term, are interesting, is the dialogue happening at a very high level, at a political level, and the executive order, the whole of government approach is not happened here in the US for decades and decades, really not since Franklin Roosevelt era. So that is policy setting. It's not interventional in individual cases. That's new. You can call that politicization if you like to, or you can call it, taking a whole holistic approach, a policy approach. It's new in the US. There are other jurisdictions around the world that have European State of the Union speeches that set the framework, strategic steers in the CMA. It's not unique to the US. You've then got a very, a push for intervention, for antitrust producing the answers to things, some of which it can answer, some of which, in my view, it can't answer, some of the problems we have economically. And again, all of that being discussed, campaigned on, frankly, during the 2020 elections. That hasn't happened for decades, since FDR's time, for example. But the critical issue is perhaps the individual investigations. Is there political influence / interference on the outcomes of individual investigations? And that's another dimension of politicization. But what we're seeing here is the use of antitrust from policy all the way through the system, much more proactively than in the recent past. So politicization can mean different things. I'm not talking about somebody somewhere allegedly picking up the phone and telling somebody somewhere else to decide a decision in a particular way. I'm talking about the whole framework, the whole environment.
Thanks. Well, we have in all Latin languages, we have only one word for the two words that you use. You have a word politica for both politics and policy. So
Very interesting.
ambiguity leads to certain ambiguous interpretations as well. Well, we're running out of time. Anyone has any more questions? If not, we will ask Rachel to give her concluding remarks.
Well, my concluding remarks can be very short, which is a huge thank you to Julian and for the opportunity, and to all of you for this opportunity this morning. I'm grateful to you for the time. I'm also grateful to you for the opportunity, because there's nothing like needing to talk about something, hopefully clearly and interestingly, to make one really stop and think about what's going on. And what I really was trying to say is, I think the transatlantic antitrust convergence divergence story is much more nuanced and complex than the headlines suggest. It's not just one case, most recently Microsoft Activision. It's the institutional differences, the two sides of the Atlantic. Sometimes it could be the differences between DOJ and FTC. I don't think we're seeing that at the moment. The other side of the Atlantic isn't just about the European Commission. I've oversimplified there. We talked about the CMA and a little bit about the Bundeskartellamt, but we have other member states that are very active as well. You know, it's different in the different areas of enforcement, mergers, conduct, the whole role that legislation and regulation is playing now. This is an area that I'm passionate about, having had the privilege of being a special advisor on international matters to the DOJ in the Obama administration, where most of my time was focused on cases and investigations that the DOJ, European Commission, and other agencies around the world were working on. Divergence doesn't necessarily mean everything's gone wrong, and maybe good reasons why there are different outcomes. Convergence doesn't necessarily mean everything has to be exactly the same. And so this, you know, my sort of concluding remark is, this is very much an area for us all to be putting our endeavors into, and really understanding what it's realistic to achieve, and you know, why there's a convergence and why there's divergence. My message wasn't everything should necessarily be convergence, but you know, my message is really to understand what is going on and what the similarities and differences are. So thank you so much, Julian. I really appreciate it. And thank you very much to all the participants as well.
Thank you, Rachel. Thank you very much. It was more than interesting, and we're now reaching the final, the end of this year's events. We are going to resume in February, and with a topic that is related to it. In fact, both February and March have speakers that will give a complementary addition to what Rachel was talking today. One is in February, we're going to have Olivier Gasson talking about the recent trends in European competition law. And in March, we're going to have Professor Herbert Hovenkamp to speak about what the goals of antitrust are, and how they're being questioned nowadays. So this will be very complementary to what Rachel has generously explained to us today. So I look forward to seeing you all in February, and have great holidays. Bye.
Bye.